will give the podium.
Oh, no, it's all right. You're great. I am Sidney Shainwald, and welcome to the 6th Annual Sidney Shainwald Public Interest Lecture Series. It is a great, great honor and privilege to have the first woman speaker in the series, and the first woman, more important than that, the first woman appointed to the United States Supreme Court. Sandra Day O'Connor is also the Chancellor of the College of William and Mary, where I did my graduate work.
Oh, for heaven's sake.
Yes. As Professor James Simon has written, Justice O'Connor is destined to take her place among the most influential justices on the modern Supreme Court. For 24 years, Justice O'Connor was a pioneering force on the court and will go down in history for acting as a sturdy guiding hand in the court's decisions during those years, serving as a swing vote in many important decisions. She opposed the call to reverse Roe v. Wade and focused on the letter of the law, not the clamoring of politicians, and voted for what she believed fit the intentions of our Constitution. Justice O'Connor was not only a pioneer on the court, but has been one all her life. As she wrote in her excellent book, which I recommend to all, The Majesty of the Law, when she graduated from law school in 1952 as one of 5 women in a class of 102 students, she was offered a job as a legal secretary. No law firm in California was willing to hire her due to her gender. Against all odds, she went to work as a lawyer and later became a judge in Arizona. As a judge, Justice O'Connor developed a solid reputation for being firm but just. In 1979, she was selected to serve on the state's Court of Appeals. 2 years later, President Ronald Reagan nominated her to be the Associate Justice, the first woman Associate Justice of the United States Supreme Court. Justice O'Connor received unanimous approval from the United States Senate. She broke new ground for women in the legal field when she was sworn in. She is a model for all law students, women and men. It is difficult to believe that before 1977, there had been only 8 women judges in our history. As reported in the New York Times in an article in 2005, O'Connor leap moved women up the bench. Roberta C. Ramo, the first woman president of the American Bar Association, recalls what a breakthrough the O'Connor nomination was in 1981. It makes me tear up right now just to think about it, Ms. Ramos said. She was a woman who had led a life that included having children, stopped practicing for a while, suffered discrimination, was a legislator, was a judge. This was terribly meaningful to all of us. The United States Supreme Court has had 108 justices. Only 3 of them have been women, starting with Justice O'Connor. She won a battle for all of us who desire a more equal society. In The Majesty of the Law, she states that she's indebted to 2 men, President Reagan and Potter Stewart, and quotes the following poem. A toast to Potter Stewart. His chivalry can't be beat. The first Supreme Court justice to give a lady his seat. Justice O'Connor has written, I believe that society as a whole can benefit immeasurably from a climate in which all persons, regardless of gender, have the opportunity to earn respect, responsibility, advancement, and remuneration based on ability. To this end, in February 2009, Justice O'Connor launched OurCourts.org, an interactive website designed to offer civics lessons to students and teachers because she was concerned about the lack of knowledge among most young people about how the government works. The inscription above the entrance to the Supreme Court reads, "Equal justice under the law." But as Justice O'Connor has noted, a vast number of our citizens do not have access to equal justice. And she urges all of us to change that perception and eliminate the reason for its existence. Again in her book, Justice O'Connor quotes Justice Holmes, "Happiness cannot be won simply by being counsel for great corporations and having an income of $50,000. An intellect great enough to reap the prize needs other food besides success." Justice O'Connor has been ranked as one of the most powerful women in America, and President Barack Obama awarded the Presidential Medal of Freedom to her, the highest civilian honor in the United States. It is a great privilege to introduce and welcome Justice Sandra Day O'Connor.
Come and join me up here. Can you hear? Now, I thought this was going to be a class and a class discussion. I suggest that all of you just kind of close your eyes and pretend like you're in a smaller classroom. And I'm going to do the same. And I think we're going to open it up to questions. Is that right, Dean, from the audience? And that was a very generous introduction. What Mrs. Shainwald did not tell you is that I'm just now an unemployed cowgirl. So we've got a few less glamorous tasks in my life now. And I'm just going to open it up, and we'll hope the discussion is useful. I do apologize that I arrived here a little late. I didn't realize how far this law school was from my overnight stay. So. And the traffic is terrible at this hour, so I'm glad I'm here. I began to wonder. Okay, so now let's open it up. And how are you going to handle this, Dean? Are there traveling microphones, or what are you going to do?
Yep, microphone's on the desk, so when you want to speak, just push your button, and I'll try to help you on finding who's out there to call on.
All right, well, this is kind of modern. Everybody's got a mic. Okay, no excuse then. Who wants to start it off?
I will.
Okay. I'm glad somebody will.
Justice O'Connor, can you share with the students what your initiative is on bringing the public into understanding the role of law and the rule of law? And if you can, help them to understand what their role might be in the years ahead on that same venture.
It seems to me that successful survival of our Republican democratic system of government is completely dependent upon having citizens in the country who understand how our government is designed and how it functions, and how they as citizens need to be part of it. It doesn't just happen by itself. And it isn't all that easy to understand. We have to teach it, and this knowledge is not handed down through the gene pool. We have to teach every generation of young people about our government and how it's formed and how it works. I think we need to start early, and our courts program, at least, is designed for middle school students. They're 6th, 7th, and 8th graders. And that's when the light bulb turns on up here, if it's going to at all. And the middle schoolers are absolutely wonderful. You must have some in your own family. They're eager to learn, and they're sort of all of a sudden grown up, but they're not the jaded teenagers you get in high school. So they are a great audience. And that's where we started with this program, and just trying to teach them the elements of how our government works and functions. we kind of concentrated on the judicial branch because I had seen so many attacks on judges during my years on the Supreme Court. It got a little tiresome hearing and reading about activist judges, secular, godless humanists trying to tell the rest of us what to do. And I didn't feel like that's what I was at all. So I thought maybe we better do some education at all levels, but start out with the younger generation.
Justice O'Connor, would you talk about the toughest decisions that you face either as a justice, as a legislator, or as a lawyer, and how you dealt with them?
Well, they're a very different process. Oh, good, thank you. Thank you. Well, the process is different in each of the branches of government. I served in all three branches of Arizona's state government. I was in the Attorney General's office in the executive branch, and that was really fun because we had legal issues brought to us by the other two branches of government, and often very interesting questions, and we got to just sit back and research and answer them as though we knew we were right. We hoped we were. And it was a great way to learn about the processes of state government. Then I ended up, surprisingly, in the state Senate as a legislator. A woman senator in my legislative district got a position in Washington, D.C., and she resigned from the state Senate, and I was appointed to fill the vacant seat with the understanding I would run in the next election and in the one after that, and so on. So I got to serve in the legislative branch, and the process there is very different. As a legislator, in the Attorney General's office, we just dealt with questions that were brought to us from people in the other two branches of government. In the legislature, you have the privilege of looking around and seeing what issues you think the legislature should be looking at and changing and working on. And then you, as an individual legislator, can generate the material you need to develop a legislative proposal. You can be instrumental in writing it up. You can be instrumental in gathering support for it and holding hearings about it to see if it's well received, and then trying to get it through the legislature. And that can be easy or tough, depending upon what the subject is and what the proposed legislation is. Some was more difficult than others. But it was a very interesting process. As an appellate court judge, it's so different because as a judge, you don't help develop the facts. You take the facts as they come to you, as determined by the lower courts. As a judge, you can't redetermine the facts. And you have to take the cases that come through the appellate court system to you as a judge. You can't say, oh, gee, that's an interesting question. I'd sure like to get to work on that. You take what comes. And you have to deal with the issue as it was developed factually in the lower courts and deal with the legal issues in accordance with the limited authority you have to deal with it. So in each branch of government, you can deal with some difficult issues. I remember as a legislator, we had to deal with the proposed Equal Rights Amendment to our Constitution, and that was a new concept when I was in the legislature. It was circulating around the country, and it was very divisive. My goodness, immediately there was an explosion of views on it. So I was exposed to widely different and rather passionate viewpoints on this amendment, and we had to try to deal with it as legislators. On the U.S. Supreme Court, that same issue ended up in court by the court being asked to review particular state laws regulating abortion to see if those laws somehow violated any provision of the U.S. Constitution. And that also turned out to be a very volatile issue in terms of public interest and input. The court had endless numbers of briefs and expressions of views about the cases that did come to the court. I was in the Arizona State Legislature when Roe versus Wade was decided by the U.S. Supreme Court. And I remember reading it with interest as a legislator and then looking at Arizona's laws to see how they complied or didn't with the laws. And then on the Supreme Court, we were confronted with several abortion-related issues, more than just a direct re-examination of Roe. It would be some related issue in that field, and some of them were tough. The questioner asked what my hardest case was, and I'll tell you, I won't tell you the name of it because it wouldn't mean anything to you, and I can't even remember it myself. But it involved a federal income tax issue. Now, if there's any area of the law where I feel sort of insecure in my understanding, it's income tax law. I don't know about you, but I never took a class in it in law school. I was terrified. So when I had to confront a federal income tax issue as a member of the U.S. Supreme Court, I did it with much trepidation. And I remember having a case dealing with some complex aspect of the federal income tax law. And we read the briefs, didn't understand them too well, listened to the oral arguments, were still uncertain, went to the conference of the justices. Now, what happens is, at the court, first, you decide whether you're going to take the case. And the justices make that decision. Any one of them can put a petition for certiorari on the discussion list at conference and say, we ought to talk about this case. And then when it's discussed, any of the 9 can weigh in and say, well, I think we ought to take this case because, or I don't think we should take it because, and we end up taking a vote among the 9 on each case, each petition that someone has asked to be discussed. And ever since about in the 1920s, the court decided that it would take the agreement of at least 4 of the justices to accept a petition for full review by the court. And we still follow that rule at the Supreme Court. It takes the agreement of at least 4 of the 9 to say, yes, this is a petition we think the full court should hear, and that's enough. You don't have to have a majority of the court. And that proposal was made to Congress, to the Judiciary Committee, by William Howard Taft when he was Chief Justice, because the court was drowning in cases in the 20s when he was chief. And he went over and said, you ought to make our jurisdiction discretionary with the court. And the members of Congress and the Judiciary Committee said, oh, well, how do we know the court would take the cases it ought to take? Maybe they'd rather just go play golf. And as a matter of fact, William Howard Taft did like golf. But he was smart. And he said, well, we'll agree that it takes the agreement of just 4 of the 9 to take a case, and that ought to be enough to make sure that the cases the court should hear are heard. And Congress liked that proposal. So that's the way it's been ever since William Howard Taft's proposal, and it still works. So there were 4 votes to take this terrible income tax case. And we had it, and we had the briefs, because then after you take the case, the parties file briefs, and they aren't brief at all. They're long and complicated, and lots of them, although we do have page limits. And then we had the oral argument on the case, because in addition to the briefs, an oral argument is scheduled, and the court these days normally allows just a half an hour per side for the oral argument, and that goes pretty fast because the time is used by the justices to ask questions of the lawyers who are arguing, and several of them are former law professors, and you know how bad they are about asking a bunch of questions, so the time goes by pretty fast. So we went through that process with this income tax case, and then the justices meet together around their conference table. Nobody else present, just the 9 justices, no staff, no secretary, no nothing. And it goes around the table. And in this country, that discussion starts with the Chief Justice and then goes around with the most senior associate on down to the junior justice. And Canada, our nearest neighbor, does just the opposite. They start with the junior justice and go up. I think I like our system better as a former junior justice. I think it's better. Anyway, we had this tax case, and it went around the table. There were not 5 votes for any single disposition of that case. Well, now it takes 5 to have a full holding of the court. If 5 don't agree, you have some minority view being expressed. And so you're always anxious to get at least 5 votes, and we didn't have it. And so that conference ended, and in those days, as is the case today, the Chief Justice makes a writing assignment to someone who votes with the majority on a particular case. Well, this was back in the days of Chief Justice Warren Burger, and that was still the theory, but in this tax case, there wasn't a majority for anything. I was assigned to write a majority opinion for the court. Well, thanks a lot. You know, what am I going to do with this thing? I don't even like tax law, so there I was. And I struggled with that thing. I mean, it was dense and complicated, and you're always afraid as a judge in a tax case that some simple thing you put in the opinion is going to upset 200 years of tax law, and you didn't even know it would. I mean, you know, it's high-risk business. So I struggled and struggled, and I finally circulated a draft opinion. And I didn't hear anything from a single one of my colleagues. Well, I finally went to my secretary. Now, are you sure you circulated that opinion draft? Oh, yes, Justice, I did. And the term, it was in the spring, and normally the court tries to finish everything by the 4th of July. And I wasn't hearing anything. I finally got one letter from one colleague, "Dear Sandra, I join." Well, that made 2 of us. And time went on, and I didn't know what to think. And finally, I got another letter, "Dear Sandra, I join." This went on until the last week that we were in session, and I had a unanimous opinion. Now, how's that? And that was the toughest thing I ever had in answer to your question. And I still don't know if we were right. Okay.
Justice O'Connor, in the years since you stepped down and retired from the bench, there's been a growing recognition in the highest courts of many states in the country of recognition of homosexual, gay, lesbian rights. And I'd like to hear your thoughts as a woman who has suffered from undoubtedly gender discrimination. What are your thoughts on the ways in which gay men, women, lesbians, queer people in general are suffering discrimination in terms of marriage rights, in terms of don't ask, don't tell policy? I'd be curious to hear your thoughts.
That's an issue that the Supreme Court has not addressed. As with most unresolved issues of social policy, those issues end up coming to the court in one form or another, eventually, or some aspect of it does. Whether, or if so, when the U.S. Supreme Court will tackle an issue in that area, I would not speculate. I mean, it's still, I've already told you, it takes at least 4 votes. I don't know what petitions are out there. I don't read them all these days. I retired, in case you didn't know. So I don't read all those petitions. I don't know what's coming before the court. I don't know how close they are to thinking that maybe that's something the court needs to weigh in on. Maybe often, when it's a very sensitive issue, it's wise to be sure that other lower courts around the nation have addressed the issue so that when the Supreme Court does take it, you have the benefit of the resolution of the issue by a variety of state and federal courts. So I don't know when or if the court is going to address the issue or how it would decide it if it did. I'm no better off than you on that. Anybody else? Don't ask me to speculate about what the court's going to do. I don't know. Yes?
Do you have any words of advice for those of us who will be graduating, or is there something that you wish you had known as a young lawyer?
Yes. I think you will be graduating at a time when this nation is still in recession. You will not find as many job opportunities as we all would wish were out there. It's a tough time in that regard. And I know that all of you have heard of many law firms that are cutting back on hiring, or law firms that will take someone and say, but I'm going to put you on leave for a year before you start, things like that. It's a very difficult time. And it takes me back in a different way to the time when I got out of law school. And there were in those days, there were lots of notices on the placement bulletin board at Stanford Law School saying, Stanford law graduates, call us, we'd like to talk to you. They were from law firms around the state of California. And I called every one of them, and not one of them would give me an interview because I was female. That was a surprise to me. I guess I was very naive when I went to law school, because it never occurred to me that if I got out of Stanford Law School with a good record, that I wouldn't have a job offer. It just didn't enter my mind. It should have, because I couldn't get any firm to talk to me. I had an undergraduate friend at Stanford whose father was a lawyer at that big California law firm, Gibson, Dunn and Crutcher. And I asked her to ask her father if he would get me an interview at Gibson Dunn. She did, and he did. And I made a trip to Los Angeles to meet with a partner in the firm. They had lovely offices, very sophisticated, very well-dressed, respectable-looking man, and he looked at my resume. Oh, Miss Day, you have a fine resume here. But Miss Day, this firm has never hired a woman lawyer. I do not see the day when we will. Our clients would not stand for it. Well, I think I looked a little disappointed. And he said, well, Miss Day, how well do you type? And I said, so-so. And he said, if you can type well enough, I might be able to get you on here as a legal secretary. And I said, well, that isn't what I want to do. I really want to work as a lawyer, so thanks for the interview. And I left. Now, I read or heard somehow that the county attorney in San Mateo County, California, which this county seat's Redwood City, had once had a woman lawyer on his staff. So I wrote him and contacted him to see if he would see me. And he did. It was an elective position, and you know how elected officers are. They're always glad-handers and glad to see you. They'll do it no matter what. So he saw me, and we had a nice visit. He was an Italian-American and very nice fellow. So he said, Miss Day, you have a fine record here. And I did have a woman lawyer one time, and I'd be happy to have another one. But the problem for me is that I get my money from the County Board of Supervisors. And I am not funded to have another deputy right now. They've given me just enough money to run my office as it's presently staffed, and I don't have any extra. I don't know what to do about that. Then he said, let me show you around the offices. And he walked me around, and every office was occupied with somebody, and we said hello and met him. And then he said, as you can see, I also do not have an empty office right now to put a new deputy. And so I thanked him for the visit and went back to the Lazy Bee Ranch and wrote him a long letter. And I told him all the things I could think of that I thought I could do for him if he took me on as a deputy. And I said, I know you don't have any money right now to hire somebody, but I would be willing to work for you without pay until you get funded to hire another deputy. And I added, I know you don't have an empty office, but I met your secretary. She's very nice. There's room in there to put a second desk if she would be willing to have me. Now that was my first job. No salary, and I put my desk in with the secretary. Now, I tell you that story because some of you may face similar problems right now due to the recession. So remember that when you do. I loved my work. It was really fun. I immediately got some great legal issues to research and answer, and it was good. And I liked the people in the district attorney's office. And I was there 3 or 4 months or so when the county attorney was made the district court, the local judge, the county judge. And he was thrilled to become the judge. And my supervisor then became the county attorney. That opened up an office and a salary. So it all worked out. Because by that time, they decided, yeah, she can probably do the job. So you may be faced with stuff like that these days. I don't know, but don't give up. You can be creative in what you do. I remember after those days in San Mateo County, I got married and my husband was drafted in the Korean War, and he was sent to Germany instead of Korea, and we spent 3.5 years out of the country. And when we came back, he took a job in Phoenix with a law firm in Phoenix. That was 1957. And I went around to the Phoenix law firms. None of them would hire a woman. It hadn't changed. So we both had to take the Arizona bar exam, and we took a bar review course down in Tucson. And while we were there, I met a young man from the East Coast who was moving to Arizona, he hoped, and wanted to practice law, and he didn't know anybody. So he and I talked a lot, and we decided that if we both passed the bar, we'd open a little neighborhood law office. And that's what we did. We both passed, and the two of us, opened a law office in Maryvale, Arizona, a suburb of Phoenix, in a shopping center. And our neighbors were a grocery store and a liquor store and a TV repair and that kind of thing. And we just took whatever we could get. And it was not the kind of issue usually dealt with in the U.S. Supreme Court. We had domestic relations matters and bill collections and minor criminal matters and, whatever. We took them and tried to eke out a living. And we took criminal defense appointments. That was before the days of public defenders. And in Arizona at the time, the judges handling criminal cases, if there were an indigent defendant who had to have a lawyer, the judge would appoint somebody, and he'd keep a list of people he thought were okay, and he'd just appoint them, and the county would pay a little money for the services. And my partner and I would take those criminal defense appointments. So we did a bunch of those, and we managed to eke out a living. But again, I don't know what you're going to face. I had to improvise. When I first got a job in the Attorney General's office, I was the only woman they had. And the Attorney General was quite unsure what to do with me. He sent me out to the Arizona State Hospital for the Mentally Ill. Now, I don't think that was because he thought I was mentally ill, but maybe he thought there were some problems I could solve out there. And neither I nor the hospital knew what I was supposed to be doing out there. It was very interesting. They were a good many blocks from the state capitol. So I got all the doctors together and I said, okay, what do you all need out here? What legal issues are there? And how might I be of assistance in doing something? Well, it turned out that that was in the days when the laws for commitment did not permit the hospital to put a patient, mentally ill patient, on a drug program and then release them while they stayed on the drugs when they were considered safe. They had to stay locked up until a court had determined they were no longer mentally ill. Well, that isn't how things worked. What really was going on, the doctor said, was that many people with certain types of mental illness could be effectively treated on a drug program, and they would be safe to be released as long as they stayed on this treatment program. And so they needed the laws changed in Arizona to allow that. So I helped them do that. I got the nurses together to ask what they thought needed doing. I got the board of the hospital together to see what they needed. I got some of the patients together. They needed a legal aid program desperately because they would get stashed in the state hospital and lose custody of children and their homes and everything else. So they needed legal help. So I got a legal aid clinic going. And I found a lot of things to do out there that certainly weren't anticipated. So again, when you get a job, you may have to struggle to get it, but there are ways to make something out of it that's useful. Okay. How long are we going, Dean?
We're going to go till about 12:10.
All right. Now, who else?
Justice O'Connor, thank you. Excuse me. There's been a lot of attention paid recently in the media to Justice Stevens' apparent pending departure from the bench. As a historically unique appointee yourself and one who has witnessed a process that corresponds to your own retirement, do you share Justice Stevens' apparent fears of an overly politicized and broken system, or do you believe in the system's ability to provide the most capable jurists to the bench?
The system that the framers of the Constitution designed for federal judges has worked, I think, reasonably well through the centuries. We've had some pretty good justices and some pretty decent Supreme Courts through the years. They haven't all been perfect, but by and large, I think the federal judges in this country have been regarded with a lot of respect and admiration, I think, at the appellate court level, at the district court level, and at the Supreme Court level. By and large, it's been quite good, and we've ended up getting some of the better legal minds in the country on the federal bench. It's getting increasingly difficult, frankly, because federal judges are not paid at a rate that is equivalent to what private lawyers get when they go into practice. In fact, federal judges have not had a pay raise since 1986. That's a long time. And many of the district court judges and even Court of Appeals judges are finding that they may have 2 or 3 children of college age who need financial help from their parents, and they're not in a position to provide enough to help their own children. And I see quite a sprinkling of wonderful federal judges leaving the bench for financial reasons. And I think that's unfortunate. I mean, you don't expect federal judges to ever be paid on the upper scale because they serve as judges because of the academic demands made on them that they enjoy. They enjoy solving issues and writing opinions and the intellectual effort that's required to be a federal judge, and in the past, considerable respect. There's less respect today, as we've seen at both the federal and state level, and the pay scale has not even kept up with what is paid to young lawyers in New York City, for instance. And so I worry from that standpoint of what's going on and whether we can expect a really respected federal bench if we continue down this path. Now, for the Supreme Court nominations, there's a great deal of public interest about them, as you know. And what really set the pattern was when television arrived and decided they would give gavel-to-gavel coverage of hearings on nominees for the Supreme Court. Now, no elected senator who's on the Judiciary Committee objects to that. My God, they get all that free coverage day after day, asking erudite questions of the nominee, and they absolutely love it. Why wouldn't they? So we're not going to see any diminution in the process. It's going to get full television and press coverage, and the nominee is going to go through it and be miserable like I was, and like everybody else is too. It's an uncomfortable thing. The only upside to it, I guess, is the fact that it is perhaps the only time that the public will be able to see and get some impression of the person who's being considered for that very high position on the U.S. Supreme Court. Once the person is in office, you might not see a lot of them again. You're not going to have cameras in the courtroom anytime soon, probably. And I just think the public will have little exposure to justices after they're in office. So it is part of the process that gives a glimpse to the public of the nominee. I don't know how many of you watched the John Roberts nomination process unfold, and his answers to the Judiciary Committee questions were just superb. I learned things. I loved it. I wouldn't turn it off. It was just really a marvelous exposure to many questions that people have, and to his responses, which were so articulate and interesting. So it's a process that is very challenging for the nominee. I remember being in front of those cameras and on the hot spot, so to speak, for 3 days. I think I'd still be there, except that the wife of the Judiciary Committee chairman decided to have a tea for me the last day, the afternoon of the last day. And she invited everybody who was anybody in Washington, so the chairman had to recess and adjourn so everybody could go to the tea. I might still be there otherwise. But it's a painful process for the nominee, and I'm sure it's going to continue just as it is for the foreseeable future. Now, is it going to result in some totally partisan vote at the end? It hasn't happened yet. We saw it on the health care bill, but I don't see any reason why we'd have quite a clear party line vote on any qualified nominee. I just don't see that happening. There would be maybe a lopsided split, but I can't believe there'd be a totally partisan vote on anybody who has decent qualifications for the position. And I suspect that's what we'll have. Maybe some split. It may not. I was lucky. I was the first woman, and I think probably the senators were nervous about voting no on the first woman, well, regardless of what they thought. So I was lucky. It was 99-0, and the one who wasn't there was Max Baucus of Montana. But he wrote me a nice letter and said, "I'm sorry I wasn't there. I would have voted for you." So, do you have time for one more?
One more question.
I was just wondering, in the state context, us your views on whether a judicial election or appointment results in better process of law and the effect of unrestricted spending in those elections?
Gosh, did I pay you to sit out there and ask me that? I love that question. One of the things that I have decided to be involved in now that I'm in retired status is that issue of the election of judges. About half of our states in the United States still have some form of judicial elections. New York State still has some judicial positions that are filled by election, I'm sorry to say. I think that is not the way we should be selecting judges. No other nation in the world elects its judges. Now, how would you ever think that's the best way to do it? The framers of our Constitution realized that. They knew that to have a decent, qualified, fair, and impartial judiciary, they needed to be nominated by the president and confirmed some way, but then their tenure and their salaries should be protected because judges have to make tough decisions that aren't always popular. Do you think that Brown versus Board of Education or Loving versus Virginia would have been decided as they were if those federal justices were elected? No way. No way. You don't, as they say, ignore the alligator in your bathtub. And that's what it boils down to. And why this state or any other state would want to cling to that system is beyond me. Now, all the states started out with appointive systems, just like the federal. And it was later that some of the states, starting with Georgia, decided they were going to have popular election of their judges. And that kind of spread around the country, and we still have a good many followers today. But it is not the best way to select them. And when I was in the legislature in my home state of Arizona, one of my projects was to get Arizona's constitution changed. We elected our judges. I wanted a merit selection system. And in 1974, we were able to get a proposition to put on the ballot in Arizona to change our constitution. And by a narrow margin, we got it changed. And I lived long enough to see the benefits of it. We really did get overall a better judiciary and a more diverse judiciary. It was very, very beneficial. So we've been lucky. I've been close to it. I feel strongly that's the way to go. And many states that have gone that route have periodic retention elections so that the voters do have a chance periodically to review the judge's background and history as a judge on the bench and decide whether they want to keep the judge in office, yes or no. And I think that's a better system, particularly if you keep some records to help the voters know who's done what kind of a job. Well, thank you. You've been a good class.
Smiling face, and then do like 2 lines for the eyes in a circle.